Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Grace Gotchling. On May 6, 2020, the U.S. Supreme Court heard oral argument in Barr v. American Association of Political Consultants, Incorporated, a case involving a dispute over whether the government debt exception to the Telephone Consumer Protection Act of 1991's automated call restriction violates the First Amendment, and whether the proper remedy for any constitutional violation is to sever the exception from the remainder of the statute. And now, to discuss the case, we have Kevin Walsh, professor of law at the University of Richmond School of Law.
Nobody likes robocalls on their cell phones. It turns out that many of these calls are not only annoying, they're also illegal. Since 1991, when the first George Bush was president, Al Gore's invention of the internet had not yet made its way to today's web browsers, and cell phones were rare and expensive. It has been illegal to use an automated dialer or an artificial or pre-recorded voice to call cell phones. That's what we mean by robocalls. Now, every rule has exceptions, and this one had a couple. One for emergency calls and another for calls made with express consent of the recipient. There did not seem to be any First Amendment free speech problem with this cell phone robocall ban, at least for a while. It had been attacked in lower federal courts, but the attacks were rejected. The courts reasoned that the restriction was content neutral. It was not targeted to particular content, but rather to the way in which the content was delivered, that is, the manner, through intrusive and unwelcome robocalls. The First Amendment challenge in Barr versus American Association of Political Consultants came after Congress added in 2015 a new exception to the robocall ban. This was an exception that allowed these annoying calls when, quote, made solely to collect a debt owed to or guaranteed by the United States, end quote. So robocalls to cell phones no good, unless it's to collect a government-backed debt. So the tricky issues in this case arise out of this government debt collection exception. Did the addition of this exception turn the automated call ban into a content-based restriction of speech? After all, the exception functions like an on-off switch, and you look at whether the switch is on or off depending on what the call is about. That's the first issue. The second issue is if the addition of this exception in 2015 made the law unconstitutional, what's the remedy? One option would be to sever or just remove the exception that made it unconstitutional. And the other would say, no, the addition of this exception just shows this was a crummy law all along and the whole thing should fall. The challengers in this case are groups that wish to make automated calls to cell phones about political matters. They contended that the addition of the 2015 exception showed that the law was content-based and that once you applied the right type of scrutiny, that is strict scrutiny, you could see the government's interest or claimed interest in privacy was not all that compelling. After all, they let in all of these calls. They lost in the trial court, but then they won, well, sort of won in the Fourth Circuit on appeal. And the reason I say sort of won is because they obtained a declaration that the law was unconstitutional, but their victory didn't have much of a practical payoff. That's because the Fourth Circuit panel that decided their case said that the correct remedy for the constitutional violation in this case was to sever, which is just a metaphor, by the way, but just to get out of the law or treat it as unenforceable, the exception. So even though they were able to show that the law was unconstitutional, they weren't able to get the restriction lifted, but instead the exception. This configuration of issues led to an unusual path to the Supreme Court. The government, the losers, sort of, wanted the declaration of unconstitutionality reversed. Whereas the winners, they got the declaration of unconstitutionality. Well, they wanted what they wanted, which was to be able to make these calls. So the government petitioned for certiorari, and then rather than filing a brief in opposition, the challengers supported it. The Supreme Court granted and heard oral arguments on May 6th. Perhaps as appropriate for a case about cell phones, the phone technology played an interesting role in the case. First of all, this is one of those that was heard telephonically. Chief Justice Roberts began by reminding people to turn off their cell phones, something he wouldn't have had to do, because if this were actually at the court, because none of those phones would have made it through security. And Supreme Court police would have given pretty stern talk about silence in the courtroom. So that was one thing. But the big thing, and what really moved on Twitter particularly, is that someone, probably a justice, who shall remain nameless here, but seems to have been fairly identified after the hashtag #WhoFlushed spread on law Twitter. One justice seems to have, taken advantage of the mobile functionality of phones by taking the phone into the bathroom. This became apparent after an unmuted line led to a flushing noise being transmitted across the internet. This all took place while counsel for respondents Roman Martinez of Latham and Watkins was answering questions from Justice Kagan. So it was pretty far into the argument itself. Now, the core arguments made by Mr. Martinez on behalf of those who wanted to make these calls were that political speech of the sort they wanted to make is core First Amendment speech, and they had a right to use effective technology, especially when that technology is something that the government allows government-approved messages to be used for. So if the government wants to say, well, we have this big interest in privacy so that people can't make these robocalls, how serious are they about that interest if they let people do it when they're just collecting money for the government? So this trade-off of privacy for revenue undermines the government's claimed interest. The respondents focused on the breadth of the ban and said that the cell phone version sweeps in political speech as well as all these other things, whereas the restriction to residential phone calls has been narrowed and narrowed over time such that it doesn't encompass non-commercial political speech. And they said because the speech ban is so broad and unjustified, the restriction itself must be struck down, not the exception. The remedy for a First Amendment violation is not to ban more speech. Those were the core arguments. On the petitioner's side, arguing for the U.S. government, Malcolm Stewart, Deputy Solicitor General, focused on the constitutionality of the law as it existed from 1991, at least until 2015, and said this law was fine, and the addition of the exception didn't change anything. That was the first argument. Second argument is, if you think that the addition of this exception for government debt collection did change the constitutionality of the law, well, then the fix is what the Fourth Circuit did, which is to eliminate the exception, the thing that causes the unconstitutionality. What you shouldn't do is take this perfectly fine and very popular law and eliminate it. The questioning of both sides revealed a bench that seemed to accept the challenger's argument that the law was content-based once this exception was added in 2015, but that was unsure about what should happen as a result of that. Some of the justices flat out said I think this law is content-based, and other of the justices didn't even bother saying that, but skipped immediately to the question of severability and remedy. And on this front, the tension was between saying sever the law, right? That is, leave in place the restriction, which seems perfectly fine for almost a quarter century and is very popular, right? That's the intuitive appeal of the government's argument. But on the challenger side, the appeal is it doesn't make any sense to have a remedial rule that doesn't allow us to get what we seek. And it is odd for the remedy for a First Amendment violation to be a restriction of more speech. So that is the tension that the court must confront as it goes into conference and then decides this case. And there are really a number of ways this could come out. And it may turn out that this case clarifies the relationship between substantive First Amendment doctrine and the doctrine of severability. And on this front, respondents, the challengers, anticipating the difficulties that would be presented, really focused so much on how the nature of the First Amendment test itself, that is, you look if the rule's content-based and then you apply the appropriate level of scrutiny, right? How that rule itself encompasses all of the potential applications of the rule under analysis. And if that is the way to understand the First Amendment test, and they succeed in showing that the rule, which includes both the restriction and the exception, is unconstitutional, then there really is no need to get to the severability question because the whole thing falls simply as a matter of First Amendment doctrine. So this one's a bit of a head-scratcher, but it will be worthwhile to see the justices wrestle with these difficult issues. The only thing we can say for certain coming out of this is that nobody likes robocalls.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.